Welcome back to another episode with ByrdAdatto. Today we are going to shift gears a little bit. We've been talking about a lot of different areas in healthcare, but one of the areas that definitely is impacting every business is your employees and the laws surrounding it. Now, we've had previous videos on this, but we brought back one of our experts on this. And Michael, would you like to make the introduction?
Well, I am glad to. Renee Coover is a partner at ByrdAdatto, and this is her second appearance on these videos. And so at the risk of over repeating what I said last time, Renee is a speaker around the country with our speaking team at ByrdAdatto, has given a TED Talk that has, I think I said a gazillion views last time, I'm not sure, but I know it's, I believe, more close to 60,000 views. And anyway, just really focuses a lot of her attention for our clients in the employment arena, and so she's keeping us up to date on the Family First Coronavirus Response Act, and I think there has been some updates.
There has. So the Families First Coronavirus Response Act, which is a mouthful and has been shortened to FFCRA, passed on March 18th, which now sounds like a lifetime ago, and went into effect on April 1st. And in that 2-week period, there was this confusion and hesitancy between what the act said and how it was actually going to be implemented. So on April 1st, the DOL came out with regulations to implement FFCRA, and they made some clarifications that are helpful to both employers and employees when figuring out and trying to determine whether your employees can take a leave under the act. So the DOL first confirmed that to be an eligible employee under the act, the employee has to have worked for the employer for 30 days and be on payroll for 30 days. And so it has to be 30 days before that employee actually takes leave under the FFCRA, or if that employee was terminated or laid off on or after March 1st of this year, they would have to be put back on payroll before December 31st to be considered an eligible employee. The DOL also confirmed for employers that to be a covered employer under the Act, the employer has to have 500 or less employees. But there are these exemptions which really encompass a wide swath of the industry, right? So we have the first exemption being for small businesses. This actually limited the playing field a little bit because the DOL in its regulations that it implemented said that for small businesses with 50 or less employees, if the employee wants to take a leave under the FFCRA for any child care purposes, meaning they don't have available child care or the school is closed, then the small business can apply for the exemption, or not even really apply, just say that they are exempt if it would affect the viability of their business, jeopardize their business. And we thought there was going to be some process to apply for this exemption, and as it turns out, there really isn't. There are stipulations that an authorized officer of the employer must fit into, but really all the employer has to do is prove that an authorized officer has made the determination that the small business is exempt, and then the DOL recommends that they keep really good records on file to show why they believe they're exempt. So there's nothing that we know of that has to be actually turned into the DOL. The other two exemptions that are applicable mainly to the healthcare industry and to a lot of our clients are, one, the healthcare provider exemption, and two, this emergency responder exemption. These are really broad exemptions that apply to not only those employees who are actually providing healthcare, but to any employee that works for a healthcare provider, and then also to employees of institutions or employers that contract with any healthcare provider. And it applies to any type of business that the state or the territory deems is needs to be responsive in response to COVID-19, needs to actually provide healthcare. So this is a huge, part of the industry. It applies from, physicians to nursing care facilities to, the janitors that work at those facilities. So it's really all encompassing. And the same goes for the emergency responders. That's going to cover anyone from a 911 operator to an EMT to the military to the National Guard. So those two exemptions really are quite broad and will affect a lot of the health, if not all of the healthcare industry. The DOL also made some clarifications when it comes to how to use the actual leave that employees are granted under this act. And the first clarification that they made was in regard to how to tie together the emergency paid sick leave with what they're calling FMLA plus, which is their version of FMLA traditional. Now it's plus because it's emergency. So there is the opportunity to use both emergency paid sick leave under the act as well as FMLA. And these two tie together. I won't go into the specifics of how this all works because there's a lot of terms and top-offs and all these different things being thrown around. But what is important to know is that the emergency paid sick leave can extend the 12-week FMLA that an employee would receive, and they can use remaining paid sick leave to fill in any gaps. So this is an important clarification, and there's certain ways to combine emergency paid sick leave with FMLA plus or potentially traditional FMLA to get a full 12 weeks of paid leave. The other interesting clarification was when it comes to intermittent leave, and this was a question among a lot of employees wondering, could they just take a few days off where they go into the office a few days, stay home, and make it intermittent? And the DOL clarified that there's only really two ways to take intermittent leave. One being that the employer and the employee agreed to do this, and two, that its use is limited to the employee's need for childcare. So this really shut the door on an employee being able to use intermittent leave for any of the other qualifying reasons related to COVID-19. And so that was an interesting clarification from the DOL. And then finally, when it comes to how an employee actually requests to use leave, this has been another question among employers and employees. The DOL clarified that there's different notice requirements depending on the reason for that employee to take the leave. So when it comes to an employee needing to take a leave because of a school closure or childcare issues, then they should be giving notice as soon as reasonably practical, which isn't really defined, but because of the circumstances, as soon as possible is really what it comes down to. But when it comes to an employee needing leave for any other reason other than childcare, the standards are quite loosened, and the employers can only require employee notice after that first day or after that first work day that the employee takes the emergency paid sick leave. And they have to be able to, the employer must accept notice of this leave, not only from the employee itself, the employee, him or herself, but from either their family member or someone that's, a representative on their behalf if that employee is unable to give the leave themselves. So these are some interesting clarifications that the DOL has made, and hopefully it will resolve a lot of the questions that employers and employees had when it came to how to actually use the leave that is being provided under the Families First Act.
It's a lot. Yeah.
A lot to take in. Yeah.
So for our Access Plus members that are watching this, if you didn't make it to our Zoom call, which is on Wednesday the 15th at 5 o'clock Central Time, the Access Plus Zoom call will be on our portal, and we will get into more details on this and the interplay between this and the PPP loans, because really what we're finding is people are trying to figure out when do they need to bring their people back and how do they characterize it when they're not there, and whether it's furloughed, terminated, or having them still being paid but calling it sick leave. And of course on this video we probably don't have time to dive deep there, but there is interplay and a lot there. And so as you're trying to figure out how to come up with your strategy, I would highly recommend that you call counsel and get some advice to kind of make sure you're looking at the whole picture.
Yeah, and I think it's a perfect case of good news, bad news. The good news is that we have more information today than we did just 2 weeks ago or 3 weeks ago when these laws were being passed. But the bad news is decisions still have to be made very quickly, and you're balancing it based on a lot of different laws that are all being released simultaneously, and we're still waiting for guidance in some of those laws. So I think that there's a lot still to learn, and obviously that's why we've been doing these videos for people to think through them. And obviously, as Michael said, and seek counsel as you need. So, but Renee, thanks again for coming on today.
Thank you for having me.
Yeah, and Michael, good to see you as usual. And we're looking forward to seeing you next time.
Thanks.
Take care.